Hi everyone, and thank you for joining us at the Legal HR Summit. The Legal HR Summit is a two-day online event hosted by Jus Laboris, the largest employment law alliance in the world. This session is part of the Euroblock and will be followed by other curated sessions of the region. I am then turning over to Alexander Milner-Smith to begin this session. Go ahead, Alex. You are welcome to start.
Thanks very much. In my notes here, I've written hell all rather than hello all. And I'm just speaking to Jessica and Annie in Belgium and others. We were describing our lockdown experience. Maybe that wasn't a typo. But anyway, hello all and welcome. Welcome to this session, which is very grandly titled COVID-19 and Privacy, a Clash of Fundamental Rights, which if that was a film, and if I was allowed to visit the cinema, I would probably go to watch. So exciting does it sound? I'm very pleased to have three panelists here who are far more interesting and erudite than I am. Jessica Jacobi from Klimt in Germany, Søren Christoffersen from Norbum V in Denmark. And actually Søren was formerly of this parish for a time, at least on secondment for a couple of years. And Anastasia Petrova from Alrud in Russia. And they're going to speak on three different topics in a moment. But first, as usual, I'll give a rather ham-fisted introduction in relation to this topic. It is trite to say that COVID has brought a new way of living in many areas, hopefully short term, but one never knows. But it has certainly brought a number of new and innovative privacy issues both into the workplace and indeed into the marketplace. Obviously, this being a Jus Laboris session, this is focused today on the workplace, but everything we talk about broadly applies to the marketplace as well. When we talk about track and trace and so on, it will all apply workplace or marketplace. And frankly, processing of data that would have been anathema in some jurisdictions and probably strongly prohibited, or either by law or by culture, certainly in continental Europe, is totally commonplace. And that's been a paradigm shift in really only 6 months, which is really quite astonishing. Intrusions on life and liberty and privacy are now day-to-day occurrences. And we were talking about that just a moment ago. Poor Annie, who is in Belgium, has had to get permission and produce some kind of paper to attend the office today during curfew hours in Belgium. So not only are there liberty issues there, but there are privacy issues, but we'll talk about them in a second. And equally, on the one hand, we hear all the time about the need to protect life, to make sure our employees are working in a healthy and safe environment, and that is the priority. But at the same time, we hear from privacy activists and indeed regulators that our right to privacy is still paramount. So we have this balancing exercise to look at as an employer or an engager of employees or workers. And it is a very difficult balance to strike sometimes. Just as a microcosmic example of that, we often in Europe are told about the superb track and trace operations in Korea, Singapore, and China. And that is often accompanied by a cry about the appalling incompetence in France and the UK and even Germany in relation to track and trace. But what is missing from that analysis is that every stage in France, the UK, and indeed Germany, when the track and trace systems are being developed, the eyes of privacy activists and regulators have been on that development. So this simply isn't the case in Korea. And don't forget, Korea is a country that is pushing for European Commission data and a European Commission data adequacy decision. But in Korea, track and trace involves the use of data from all streams, CCTV, credit card data, geolocation data, similarly in Singapore and so on. And yet in the UK and certainly in Europe, rightly or wrongly, privacy concerns have taken precedence, and we then decry the alleged failure of our systems. So this is obviously all very relevant to the workplace, and all these top ideas are things that we as data and privacy lawyers, workplace lawyers with an interest in data and privacy grapple with every day for our clients. And I'll just coming to an end in a moment, and I'm going to move over to Jessica. But the IAPP, which is a very prestigious data organization of which many of us are members and have various certifications from, in their brilliant read that I recommend you all read, Privacy in the Wake of COVID, Remote Work, Employee Health Monitoring, Data Sharing, sum it up better than I can, I think. They've said, whilst COVID-19 has led indirectly to an utter transformation of everyday life for most people around the world, data protection authorities have made clear that fundamental rights and freedoms must continue to be protected during the pandemic, and that existing data protection rules, such as the GDPR, continue to be enforced. And in fact, they've actually said further that most of the respondents to a survey that they did have actually said that privacy has not at all become less of a priority due to the pandemic, but rather has been elevated up the risk register. So there will be businesses and workplaces that have probably never thought about privacy in the way that they have been doing over the last few months. So that is the paradigm and the idiom that we're in and that we're going to talk about today. And I'm going to move on to Jessica in one moment to lead us off on the kind of novel processing and technology that we're seeing in the workplace, which has been deployed in response to COVID. But just before we do that, and I hope this works, and I'm just going to trail Annie, we've got just a very small poll from the viewers just to see whether any of you have had any novel data and privacy issues arising during COVID. Now, I understand this is very easy, so I think it takes a few moments. If you could all just vote now, if you so wish. I would hope it's probably anonymous. I think it is from a privacy perspective. And then we'll see those results, which I suspect the answer will be 100%. And I have no idea how long this goes on, but there we go. Will we see the result, Annie? There we go. Oh, how fascinating. I'm completely wrong. That actually looks a lot like the US election, which I shan't talk about, although I suppose slightly inverted. So I'm as bad as the pollsters in America. But there we go. So only half of you have had novel issues arising, which is interesting because we've obviously been doing a lot of advice on it. But I'm going to take that opportunity to move over to Jessica, who is going to speak about some of the novel practices that we're seeing over the last 6 months. And Jessica is on mute, but she won't be in a second.
Thank you, Alex. Yes, thank you very much. The German approach is quite traditional. There is a principle in tackling COVID-19 at the workplace, which can be summarized with the word TOP or top. It expresses that technical measures are to be taken before organizational measures, before personal measures. So that means that the first choice of responding to COVID-19 would be to send everybody home wherever possible. That creates a whole new bunch of issues, the home work, the remote work, we know. But this, of course, helps to interrupt infection chains, and you do not even need to trace anybody. If they are at home, they won't be carrying any infection to the workplace. And so other technical measures are, of course, those screens, which we now all see in stores and sometimes in workplaces. Organizational measures are things as shifting, as separating groups of people, and in an early shift and a late shift, or 1 week and the other week. And only the third thing is personal measures. And this goes into who's wearing a mask and also whom do I trace. And regarding those more technical things or personal things and the processing of data, of personal data, there is a clear statement that data privacy rules are still applying. There is no, as you already stated, it's still binding law. And of course, it is possible and required to process who is sick, who is not sick, who has had contact with somebody who is infected, who has been traveling to a risky region. This can be processed. It should be deleted as soon as possible. This is what the guidance says. And one more thing is that there was a clear statement. You just mentioned, I think it was Korea, or was it Hong Kong, one not so democratic country at least. So in Germany, there is a Corona app, but there was a clear statement from the government that it must be voluntary, and that also it cannot be made a requirement to enter anywhere. So as of yesterday, we have 20 million subscribers out of 80 million Germans for this app. And this, of course, makes it difficult to really work, as you can imagine. So what else do we have special in Germany? We don't believe in temperature testing. Apple Store in Frankfurt gave it a try, being a US corporation. And you even see it today. I just saw today on the news from US, they are obviously heat testing their voters when they come to the election. We don't do that in Germany at all. We don't believe in temperature testing. Of course, it may be a symptom, but it's difficult, it's inaccurate, and it's not allowed. So this is the German perspective. I can go more into detail if you want to.
Well, thanks very much. That's very interesting, because I must say in the UK, it is very, very different in that we have had very clearly a kind of cascade upwards of what employers are doing, from basic travel questionnaires at the start of the pandemic. You know, have you been to, at that time, Northern Italy, I think it was. Travel questionnaires obviously slightly have died away now. They were then replaced broadly by health questionnaires. Are you feeling ill? Do you have a temperature? Do you have a fever? And then there is a quite widespread usage within the workplace of varying temperature testing technology. In and of themselves, it can be very basic, from a home thermometer test where we're not taking any data, but a mandate that one must take one's own temperature at home and not come in if the temperature is above whatever 37.8, to far more complex systems indeed that Lewis Silkin use in some ways. When I attend the office, as I do each week for a couple of days, there is an automatic temperature scanning module or machine that will give a certain tone to the receptionists, and if my temperature is above 36 or 37.8, then actually it's never happened to me, so I have no idea what would happen, but I imagine I would be bundled to the ground and removed immediately. And then we have advised a number of clients on even more interesting kind of use of technology, from combination of artificial intelligence and ID verification and facial imaging and temperature tests. With then even further on, we have also advised some clients on the use of PCR testing. So having a PCR test and only being allowed to attend the office if you have a valid, clear PCR test each week. And indeed, we have advised some clients, although this is very rare, on the use of antibody tests. Now, antibody tests are obviously quite controversial because no one really knows what they show. And indeed, most clients are not using antibody tests at all, but there are some clients who want to know what proportion of their workplace have the antibodies, potentially because in future that will be relevant for vaccines and so on. So it is, I feel that maybe we live in a society that doesn't care so much about privacy, but the final point, and then I'm going to ask Anastasia and Soren about what is most common in Denmark and Russia, but we have also advised a number of clients on internal track and trace systems. So nothing to do with the government track and trace scheme, which I think also in the UK, I think our download is at around 25 million out of 65 million people. Which is decent, but not probably enough. But there are a number of companies who do produce internal track and trace models. So you could be on a work floor, a factory floor, and you wear something around your neck which tells you how close you have been to another of your workers, and it can monitor adherence with distancing policies in the workplace at one level, or slightly less insidiously, it can of course just help you track an outbreak. So if someone does have an illness, you can then tell those people who may or may not have been exposed what they can do. We're obviously going to come on to the legal issues with these particular processes in a second, but Soren, what about Denmark? Are you more of a German model, which is, to be fair, Jessica, slightly less privacy intrusive, or are you more of a UK model where there is more intrusion on privacy and perhaps privacy has taken a slightly back seat?
I think probably somewhere in the middle, but probably closer to the UK position or situation. But we've seen quite a lot of clients asking about whether they can do temperature testing in the workplace, even COVID-19 tests in the workplace, various apps deployed. One client asked if they could put an app on the employees' work phones to maybe they would prompt a couple of questions that the employees would have to answer. But from what I can hear, we are quite close to what you're facing in the UK, Alex.
Thanks, sorry. And Anastasia, anything different in Russia? Anything unique?
Hi, everyone. So in Russia, we have very detailed prescription from the authorities regarding what information shall be collected and for what purpose in order to prevent COVID-19 spread. But at the same time, we don't have sufficient regulation on how it can be done. So we don't have any clarifications whether we can use technologies in order to make contact tracing or collect body measurement temperature or not. So with this, many of our clients come to us with the question how they can use certain global technologies which are used globally by their companies in Russia in order to do this contact tracing, or for example, how they can ask employees to fill in health questionnaires via websites and applications, because all this is not directly prescribed by Russian regulators, and this leads to questions: what is the lawful basis for using these technologies? So that's what we have, and we have, of course, to advise that to be on safe side, the clients have to take certain additional measures and to ensure that there is no privacy violation, like obtaining consent of employees who will be using such technologies.
Thanks, Ajay. And we're going to come on to some of the lawful bases and some of the law in a second. What's quite fascinating, obviously, Russia is outside the clutches generally of the GDPR, obviously not the extraterritorial elements of it, but we are not talking about them today. And yet we have here the UK, Germany and Denmark. We're all under the GDPR, and yet we all have very different, maybe not Denmark and the UK, but a different cultural sort of approach to dealing with COVID. And indeed, we at Lewis Silkin have dealt with many, many international projects over the last 6 months, and the position in France is broadly more similar to Germany. The position in Italy is frankly does fluctuate, but is again perhaps more similar to Germany. And yet we have seen in some of the Scandi countries, so Denmark and Sweden and so on, perhaps a position more akin to the United Kingdom. And indeed in Ireland, Ireland is very similar to the United Kingdom in what kind of testing is happening. So it is quite a strange thing, because of course one would assume that GDPR would produce a uniform approach. But as we all know, there are nuances both from a domestic legislative perspective, but it also, it seems, from a cultural perspective as well. And I think, Jessica, unless you've got anything else to say, I might move on to the poll, if that's okay.
Excuse me?
Unless you have anything else to add on this topic, I might ask Annie to move on to the next poll.
Yeah, absolutely. Cool. Go ahead.
Thanks, Jessica. Sorry. So this poll, we're very interested in how many of you have actually deployed any of these things. And just while you're answering that question, someone has, perhaps not, it's not quite a question on the Q&A, but it's a statement that they say they have also been temperature tested at the Apple Store not too long ago, a restaurant, and of course at the hospital. So I'm not sure if that's in Germany or in what country, but I think it is just part of life. And I wonder whether that is part of life for the next 2 months, 6 months, or 12 months, or for the rest of time. One doesn't know. For those of you that travel in Asia a lot, when I first started going to Hong Kong and Singapore, even outside of the COVID pandemic, the prevalence of mask wearing is something that is far more common in Asia than it is in Europe. And so, you know, one wonders whether temperature testing in the United Kingdom will still be around in 20 years. Anyway, so here we go. It's interesting. So travel questionnaires more common than health questionnaires, more common than temperature testing, although quite interestingly, internal contact tracing is quite common. I wonder whether that is internal contact tracing in a very informal sense, i.e. if someone were to get it in the room 27 of your office, you might then try to make sure that anyone who has been in close contact is alerted, as opposed to a formal use of an actual tracking app within your company. But obviously, we're not sure about that. And COVID-19 testing, obviously, the least common, although 30% out of only 23 responses. But that's more common than perhaps I would have thought. Maybe all those companies are in the UK and being advised by by Lewis Silkin. I'm not sure. And I do think the next thing, and I wonder, slightly outside the privacy context, but I do wonder when a vaccine is available. Notwithstanding what the governmental positions might be on mandating the delivery of a vaccine, or if everyone has to have it, whether companies might actually mandate their employees to have a vaccine, which I think would be a very difficult call to make, not necessarily from a privacy perspective, but I think that could be the next big thing. We're having a rollout of vaccines. And each year in the UK, in around September or October, we are encouraged at Lewis Silkin to have a flu vaccine. I imagine it's the same in all Germany, Russia, and Denmark.
We just discussed it. It's interesting that you mention it, Alex. We as a firm discussed it and made a poll among our staff, and there were not so many that were interested. And I remember in my US law firm in New York, everybody lined up and got a flu shot, maybe except for 5 people who didn't want to. I don't think it was mandatory. And of course, it's not mandatory for us. We just decided we make a statement. We will pay for it if you would like to have it. That was our solution for it.
And that's the way in the UK mainly as well. No one can be forced, but I wonder whether when we'll all be asked to advise on this, no doubt I'll be asked to advise on the privacy implications of forcing people to take this new vaccine. I wonder, Anastasia, before I move on to your topic, correct me if I'm wrong, is there a vaccine in Russia now? And is anyone being forced to take it to come to the office or anything like that?
Actually, Russia has developed a vaccine, but currently it is not obligatory for any employees of private business. So, and we haven't heard of any examples where private business have introduced any policies regarding vaccination of their employees. So it may be now like experiment for maybe certain state officers who take this voluntary, but not on private business level.
Okay, well, we'll have to see how that develops as vaccines are rolled out, one hopes, across the world. Now, we are going to move Anastasia on to your little mini session. Anastasia is obviously in a slightly different position to Soren, myself, and Jessica, in that we all come from a GDPR jurisdiction, Russia not being under the GDPR. But I thought that Anastasia would talk for a few minutes just on the legal issues that are raised with the processing use cases and uses of technology that we just discussed. So what lawful basis do you need to process health information and so on? And then I'll chip in with some GDPR ideas, and so will Jessica and so on. So Anastasia, over to you.
Thank you, Alex. So I think that a very demonstrative way to talk about legal issues that arise due to COVID-19 from perspective of data privacy is to discuss 3 examples. So I will be discussing examples which are relevant to Russian jurisdiction. So in Russia, as in other countries, we have many prescriptions from health authorities and from the government regarding collection and processing of certain personal data related to health. So in particular, employers are required to collect information on certain chronic disease of employees, on the body temperature measurements, on pregnancy status, and also on the age of the employees, because people over 65 years old cannot be admitted to work in the office. Additionally, on the regional level, we have even more strict requirements. For example, in Moscow, the mayor has required all the employers to file information regarding their remote employees to the website of the Moscow mayor and the government. And this information includes, in particular, phone number, transport card number, and car number. So, of course, this information is quite sensitive, taking into account that each person can be tracked with this information. And so in this context, of course, we see a lot of questions, how to comply with all these requirements without violation of privacy. And many legal issues arise. So my first example will be regarding whether it is possible to use technologies, and in absence of violation of privacy. So as I told, in Russia, we have a lot of prescriptions what to do, but we don't have regulation how we can do this. And of course, many companies, especially Russian subsidiaries of international companies, they are very keen to use technologies as the most effective measure to do contact tracing and to obtain certain information regarding health. But if they do this, unfortunately, they cannot safely rely on such lawful basis as processing in order to fulfill legal obligation, or processing in order to protect life, health, and vital interests of employees and third parties. Because in Russia, regulator treats this lawful basis very narrow. And so if this particular processing is not provided by the regulator's recommendations or laws of Russia, then we cannot rely on this basis. And the most safe option will be, the safest option will be to rely on the consent. And so our question is what to do if employee refuses to provide the consent or finally objects this processing when it is ongoing. This is a question for many subsidiaries of international companies in Russia, whether to use globally produced tools or to avoid their using in Russia due to this question, due to this problem. And so maybe Alex, you can comment what happens in UK and how this can be dealt with in UK, because in Russia, I'm sorry, in Russia the problem arises also because we don't have enough clarifications regarding use of legitimate business interest, and this concept is very weak, so we don't have this lawful basis to rely.
Sure, I'll give a general European position. I mean, as I said at the start, all privacy concerns are in play. There's no particular exemption because we're dealing with COVID. So yeah, we're battling with similar concerns. Always the first thing to think about is what is the lawful basis for the processing. I've always described that as the threshold condition, because without that, you cannot cross the threshold into the actual processing and then all the other stuff you have to think about. And it's fascinating because there's a different approach all across Europe, again, even though we're all under the GDPR. The Information Commissioner's Office in the UK has actually been beautifully vague and also prescriptive, a rather wonderful combination, in that they have said it's really up to us as the data controller to decide how we do this. So they have suggesting even for testing, which is obviously clearly anathema in Germany, but for testing even, there would be a lawful basis. There would be both legitimate interest and then potentially legal obligation and or public interest in certain cases. And they've said that in terms in their guidance. And then they also talk about, limited retention, keeping things secure. Of course, if you're using an innovative tech or you're using a third party, ensure that they keep their data secure and so on. But most relevantly for that lawful basis question, although they've said that, they then also cover themselves by saying, of course, the processing must be proportionate. And so it's then really up to the employer to decide that. So we have a similar situation to Russia in that there's not that much guidance, but what guidance we have broadly allows us to make a decision that we wish to. And that's why I gave a reference earlier to antibody testing. It would be very difficult to process antibody testing when the scientific community is split on the efficacy of antibodies and so on. That would be very hard to say that was in your legitimate interest and you needed to do that because of a legal obligation. However, it's very different from a PCR test perspective, because you could just about argue that that is necessary to protect the health and safety of workers, and you think it's proportionate for your business. But it's fascinating because I'll come to you, Jessica, just for 30-second colour in Germany, and then you saw in Denmark. The position is different in Germany, isn't it? I think, Jessica, in relation to lawful basis.
Regarding lawful basis, yeah, we don't do things as contact tracing. So most of the things we do, the legal basis is narrower in Germany anyhow, because in the workplace, it needs to be required more or less for the performance of the contract. It cannot be legitimate interest. And consent is very limited because, as you said, Anastasia, you need an alternative. Otherwise, it's not voluntary under German and under GDPR law. So if the person cannot come to the workplace anymore, then it's not voluntary, because ultimately you force them into doing, or you just get their signature, you force them into signing, but it's not considered to be voluntary. What I was wondering, Alex, is if you do, when your clients try to or want to use a contact tracing app, would you advise them to do a DPIA, data protection impact assessment, just to have something on the records?
Yes, always. I mean, whether that is technically required under the auspices of Article 35 is a different point, but most advice I give now in relation to almost any facet of data processing, COVID related or not, does involve the suggestion that a DPIA is a good idea, because it papers your thought process. So if you were going to put in place a COVID-19 internal app, why wouldn't you do a DPIA that explains why you think you have a lawful basis, shows the due diligence you've done on the third-party company providing the app, shows that you've thought about data minimization, i.e. only 4 people in the organization will have access to the contact data, shows that you've thought about security, not to mention it, but shows that you've thought about max Schrems and extra EEA transfers, and I won't go on. But I think a DPIA, whether it's contact tracing, health questionnaires, travel questionnaires, anything, I think a DPIA doesn't solve anything, but you will want to have that in your back pocket if there is ever a complaint, either from a data subject or from a regulator. So that's a very good question. And I think, Soren, just maybe 5 seconds. No, that's far too little. 12 seconds on Denmark and lawful basis.
I'll speak fast. I've actually become increasingly relaxed about advising on different initiatives that employers want to take during this pandemic. I was very nervous in the beginning, but I find it fairly easy to identify lawful basis. The question I always ask clients is about proportionality. Do you actually can you achieve what you want to achieve with less means? And I always mention previous impact assessment, no matter whether it's technically required or not, because in that way you get through that thinking process of whether you need to do stuff, and also you can use your previous impact assessment as a communication tool to your employees. And if you do that efficiently, and I think that goes back to the cultural perspective maybe, but here in Denmark I find that the clients I've been advising on this point, they don't get objections from the employees, because they have considered what they're doing and they've presented it in a good way to them.
And I think, sorry, the communications point with employees is almost the key thing.
Would you publish it? Would you advise your clients to publish the DPIA internally inside the company?
I was going to come to that. I probably wouldn't do that, but I would at least say that we've done it, and I would include a lot of transparency about anything we want to do, because a works council will expect that.
Yeah, absolutely, they do.
And it will just, well, it may be mandated, mightn't it, Jessica? So, but they will. It just will help smooth over any problems, because if we think about what our rationale is here, we are not faceless tech company mining data to monetize it. Nor are we a state actor using data because we want to hold down our citizens. We are simply employers trying to create a health and safe working environment so we can all have a living and exist in a difficult world. So whether that's altruistic or not, I'm not sure. I probably should look up the definition of altruistic, but it's not malicious. So I would hope that a regulator would go easy on anyone, and that's where a DPIA really helps. I think it shows that you, in a difficult, nay, an almost impossible situation, you've tried your best. Now, there will be examples. In Germany, it sounds like there are some very strict prohibitions on temperature, and so if you do that, more fool you. But in Denmark, and to a lesser extent Russia, but certainly the UK, it's a little bit more of a free-for-all, and as long as your thinking is not absolutely ridiculous, you're very likely to be okay. As one example, Soren talks about proportionality. If you were to put a drone over someone with a temperature test and follow them all the way home, testing their temperature every 5 seconds, even Soren would be less relaxed about that. So a fatuous example, but proportionality means many things to many different people. And as long as you're somewhere along the continuum of proportionate, you're probably going to be okay. Anastasia, I'd just like to come to you for just one last minute, just to finish off your session before I move on to Soren, if that's okay. So just one more minute. Thank you.
Yeah, thank you, Alex. And another example is a battle between privacy rights and reporting requirements. So I already mentioned the requirement of Moscow Mayor to provide certain information on the employees via website. But the decree of Moscow Mayor is absolutely silent regarding whether this information must be collected by the employer from the employees and whether employees are obliged to provide this information to the employer. In this context, we again don't have this lawful basis if employer doesn't have already this information. So we don't have lawful basis for its collection if we don't have this information. And in such situation, employers have to choose whether they will have potential violation of employee privacy or violation of the authorities' requirements. So that's, I think, a very good example which shows these legal issues which arise. And another one very specific is a battle between retention period and again reporting obligations. So in Russia, Russian Health Authority is entitled to check compliance with the requirements. And in order to check, it often asks to provide logs with, for example, body temperature measurements or logs containing certain filled in health questionnaires, which employers introduce in order to fulfill the obligations. And we see that many employers are not able to provide this because the retention periods for this data have expired. And when they are checked, so they are fined because they cannot prove that they have complied with health prescriptions. And we already have a certain judicial practice in this regard, which states that that employer is entitled to refuse in provision of this information due to privacy reasons if retention periods have expired. And this is something what is quite positive from privacy perspective.
Thanks very much, Anastasia. And I'll just make one comment on both of those streams. Reporting is an interesting one in that you are absolutely right, you have all these privacy concerns that you might have worked through all the way through. You might have done your DPIA, you might have been transparent. And yet suddenly the law changes, as we found a little bit in the UK, or suddenly people start saying that one piece of legislation, for instance, in our world in the UK, care of hazardous substances or similar, suddenly requires you to report positive COVID tests or symptoms and so on of your employees. And you might not have told them about that. So you can have a transparency failure there. So it is quite important, as always, privacy is not just about your privacy stream. It should involve lots and lots of different people around the business. If you have a health and safety officer, they will guide you about what the rules are about retention and reporting. And that brings me on to retention, Anastasia, because that's a very interesting point. The GDPR talks about keeping data for as short a time as possible, but you are right, Anastasia, you might then have local rules, and I'm thinking specifically of the people on the call today, many of whom will have EMEA responsibilities. It's quite hard to operate a global retention policy for this kind of COVID data when in Czech, when in Russia, when in Germany, when in Denmark. There might be different statutory rules on how long you need to keep this data. So you have this push and pull, and it does unfortunately require local advice. We're just going to have the last 5 minutes from Soren on just a little bit of colour on what sort of the central government and central organisational guidance, for instance, the WHO, has been on privacy and what kind of testing they're recommending. And then we can talk about what it's specific to Russia, Germany and the UK, although we have already all touched on what our regulators say, or in Russia, maybe the lack of what they say, and in the UK, obviously, the slightly vague comments. But Soren, I'll hand over to you now just for 5 minutes.
Yeah, I shall be very brief, and actually that is relatively easy on this topic. I've looked at some of the guidance coming out of the international organizations, the World Health Organization, the International Labour Organization, and and some of the EU institutions and the Council of Europe. I think the main point we can take from what these different organizations and institutions are saying is that they come out with a lot of different initiatives and suggestions on what employers can do in this pandemic, but they're not very clear on the data protection implications. I think at most what they are willing to say is that you do need to, as an employer, have to respect the data privacy principles and regulations when you are carrying out whatever initiative you would like to implement. The World Health Organization came with some guidance at the very early days of the pandemic in March, when it really broke out. It was mainly employment initiatives. So, and it's something that seems perfectly normal today. It's also become an everyday life, which is scary, but it's stuff like wash your hands, distance yourself from your colleagues, isolate if you have symptoms, that sort of stuff. And then they encourage employers to have contingency plans available. So to have a plan if there is an outbreak in the workplace. And there was some fairly interesting comments about how to conduct meetings. I think now most employees are probably working from home, so I'm not sure how relevant it is anymore. But there was a recommendation from the World Health Organization to make sure that you retain the data of those who participate in meetings at least for a month. And obviously, there's nothing in that particular guidance about what data privacy implications there would be with that, but obviously there are some, and I think we pretty much touched on it now. You need to consider all the data protection principles, but of more specific guidance that has come out of the World Health Organization is something I found which is really useful. Actually, it's ethical considerations to guide the use of digital proximity tracking technologies for COVID-19 contact tracing, and this is mainly something some guidance that goes towards health hospitals, that sort of stuff. But they do explain some data protection ethical issues here, and the underlying thing, as I said before, is that they explain that you need to respect those principles. And then they put out 17 principles, and they could go across every kind of technology any employer would like to use, what things that you should think about when you implement these sort of things. And that's in the COVID-19 context. So it sort of helps you in your considerations when you're doing that. And I'm happy to provide a link for that guidance after. But other than that, what we've seen from the Council of Europe, from the European Data Protection Board, the EU Commission, I think is that no matter what you do, you still have to respect data protection rules. There's been one particular statement from the European Union Commission, which came out because apparently in Hungary, the government suspended data protection rights more generally. So anyone could be more relaxed about it. And as a reaction to that, the Commission said that, yes, it is correct that under Article 23 GDPR, you can restrict the rights in certain situations, but you cannot completely suspend them. We've seen a sort of similar example in Denmark. There was an executive order that allowed certain public authorities to not notify as thoroughly as they normally have to, but that was okay under the circumstances. I think that is what I have time to say right now. But in Denmark, the Danish Data Protection Agency has not said anything more really than when you do take initiatives as an employer, you should look after your employees. But what you can normally do as an employer in terms of initiatives is what you can still do now.
And that's very useful. Thanks, Søren. And indeed, that obviously mirrors broadly the UK position. And I'll just come to Jessica and Anastasia for one final comment on Germany and Russia in a second. One other example is the European Commission, when track and trace was being first discussed, were very clear it must be voluntary. So there's an example of what I was talking about, the difference between Europe and South Korea, China and Singapore in their track and trace. It must be voluntary. It must comply with the data protection principles. These are things that are said on high and we must follow them. Jessica, 15 seconds just on this, and then I'll come to Anastasia and then I'll wrap up.
Thank you. I would start by, yes, please, Søren, can you share that link to the ethical considerations? Because I found that very interesting, and it would be a bit different from the German guidance. Yeah, as I said, the German guidance is really not so much. They don't believe in processing of data as a solution against COVID, I think would be the summary. They agree that some data need to be retained, but as little as possible. So it's still very much in line with the general German thinking when you have other projects which we've shared in the past of implementation of any kind of new software. Germany is very restrictive. We just had a 50-year anniversary, by the way, of the oldest worldwide data protection law. I think it was from Hessen. So that's a bit of the German spirit.
So Jessica, and I'll just do 5 seconds on this. As you mentioned, Hessen, there are obviously regional regulators in Germany.
Yeah,
Berlin, Hesse, Wittenberg, and so on. As we've seen with Schrems, there is a slight difference in the regions. But is there a uniformity across the regions in Germany on this? Okay.
Yeah. But what I was talking about now, COVID, this is based on the federal level. Oh. There are some additional, not very helpful statements from the Berlin level as well, which are...
Berlin is usually unhelpful in relation to data, but we'll talk about that another time. Anastasia, just 3 seconds on Russia.
Yes, actually, I don't need more because we have only one clarification from our authority who said that employer can collect body temperature in order to ensure that employee can be admitted to work. So that's only what we have. And in such case, the consent is not needed because it is in context of labor law.
Okay, that's very interesting. And I think, Annie, it's now 2:45. So I will hand over to you, Annie, and I just thank you very much to everyone. I hope you enjoyed that feedback, always welcome. Søren has shared that link, which I think we should all have a look at.
Thank you.
And thank you, everyone. Thank you to the panelists. Very, very good. Stay safe.
Thank you, Alex, for moderating.
Thank you.
Thank you, guys. So we have now then reached the end of this session, but the Legal HR Summit is not over yet, as we're going to continue with other regional sessions with the Americas later on today. So on your screens, you can see the titles of the next simultaneous sessions for the Americas. So finally, also from me, I would like to thank everyone for attending this session, and thanks also for our panelists for their important insights. So with that, this session will now be ending. I hope to see you at the next one.
Bye-bye. Thank you.